I'm representing the Electoral Commissioner as the legal counsel. Okay. Please reintroduce yourself. My Lord, my name is Enoch Ajari. Okay. So we begin with an opening statement from the petitioner. My Lords, we are most grateful to the cooperation of the court. My Lords, I'll go straight to the point. In our suit against the credibility of the voting software by the Electoral Commission. My Lords, this competent court of justice has helped us by establishing the fact that the voting system of which the EC used for this particular elections on the seat of August was compromised and also was insecure. My Lord, the question here is, who amongst us here, the stakeholders, audiences gathered, my respondents as well, my Lords, your competent selves, who amongst us here will go into an election with a voting software that has been found to be compromised and insecure? My Lord, I would like to prove with events that, my Lord, it is not only the voting software that was compromised and insecure, but our EC in every way shown to be incompetent in dealing with issues. My Lord, indeed, they say heavy is the head that wears the crown. But in fact, if the neck and the head is weak, the crown will surely fall. My Lord, I would like to go into the constitutional instrument of the EC. My Lord, in this, I would like to say that it's important to note that a constitutional instrument is a document that is carved out from the Constitution. Respondent, kindly take your seat. My Lord, can I please proceed? Respondent, this should be your last time in doing this. My Lord, can I proceed, please? Thank you. It is a document that forms part of the Constitution and in every way has the powers and backings of the Constitution. My Lord, if you will refer to me in the CI of the EC that was used for this election in Article 13, my Lord, that will be Article 12. Article 12. My Lord, clause A. My Lord, it reads, the electronic online voting system shall be used since it has proven to be effective in the immediate past SRC elections. My Lord, Article 12, clause A in the SRC Constitution or in the CI? My Lord, I actually said the CI. We don't use articles in CI, we use sections. Articles are used in Constitution. So I opened to Article 12 and it wasn't there. My Lord, thank you very much. My Lord, the CI section 12, clause A. The electronic voting system, the electronic
Section
online
and subsection, please.
section 12, subsection A. The electronic online vote casting system shall be used since it has proven to be effective in the immediate past SRC election. My Lord, the assumption and then the argument here is that the electoral commissioner decided to count upon the integrity of a voting system, which today has been proven by the competent court that it was insecure. He actually, his premise for using that was last year it was effective and then there were no issues. My Lord, we don't want to go into it that there were petitions against the voting system after it was used. But my Lord, let's move from that. But when a leader begins to actually think like that, my Lord, we stand to question that was the conditions and the circumstances last year when this online system was used, is it the same as this year? My Lord, technology keeps developing. New everyday things about hackers and how things go on with the system actually keeps popping up. So, my Lord, the respondent didn't actually take into recognition that it is not just about what was used last year, but it's about coming out with a robust system that over the years, for that 1 year, can actually meet the circumstances we have now. My Lord, in this case, it shows how flawed it was when they started. My Lord, on that same section and subsection, on that same section, section 12, my Lord, if you go to subsection F, the electoral officer shall generate a PIN for each student using the portal login information of the student, which will be used together with the student's portal login information to gain access and vote. My Lord, in the same voting system that is using last year, the electoral commissioner comes in and says that he is going to use portal login information. My Lord, you can remember that this, at the end of the day, wasn't what it was used. My Lord, let's even ask ourselves, that particular online system, when it was first used last year, it was not login that was actually used. It was the portal passwords that we used. My Lord, when it comes to evidence, we'll give a witness to give credence to that part. Somebody, an aspirant who was in that election, and then we say it for the record of the court that what was used was actually portal password. So this one shows the inconsistencies. One, you are using a system that last year you are saying it was effective. You don't know what happened within the 1 year. And again, you are saying that you are going to use a login system, which in that last year they didn't use a login system. My Lord, moving from there, the inconsistencies started showing. My Lord, at this venture, I would like to tender to the court through our competent clerk a couple of exhibits.
So let's get this clear. Moving forward, you table your witness, your evidence before we start the case hearing, please. You make sure you label them very well. Gentlemen, the guy in the long sleeve, why are you back, please? No, you, don't look back. Yes. No, you. The gentleman in the long sleeve, blue, yes, you. Blue, you were asked to go out. Yes, you were asked to go out. We only permitted you because you were counsel to a petitioner. You are done with your case, so kindly excuse us, please, respectfully. You can come in when we are about to give the verdict for your case. Thank you. So moving forward, you have to let us know all your evidence and your witness before we start the case. So if you have any evidence, if you have any witness, kindly label them well and let us know. So in your submission, you refer us, ideally, as opposed to make 7 or 8 photocopies. So we all have one to look at. But we are going to pardon you for just bringing one. That is going to inconvenience us, but we will make do with that. So let us know all your exhibits before you start. So as seen in Exhibit A, then we go through. You don't talk and come and tell us that this. It's going to elongate the process.
Thank you very much.
Label it well, so that when you are making reference to as seen in evidence, this.
Thank you very much, my lord. What we submitted is well labeled, and then we are working on the concerns you have mentioned. We are most grateful for your cooperation. My lord, if you refer to the first exhibit 122A, 122A, my lord, you find out that this was a communique the EC sent to class reps, requiring them to actually collate UHA's emails, to collate active emails, active contacts, and the names of students. My lord, every class rep of this dear university took it up, and just in a period of a few days from the weekend, you can see the date in there from 31st.
Kindly let the court know the timeline, please. From so this communique was on the 31st of July, 2021.
Thank you very much. So, my lord, that was a communique they sent from the 31st of July to class reps to actually collate all these infos that I talked about. And the deadline for them to have actually done that was the 2nd of August. My lord, the class reps went into this, collated all these documents, and then it was in the hope that the EC, who had actually planned to use login, PIN, will actually go with the email system and all these information that they are gathered for the elections. My lord, let's move away from Exhibit 122A and then come to Exhibit 122B. Exactly, my lord, that would be Exhibit 122C. My lord, you have that. My lord, that is, again, that is an educational news outlet that was released by the Electoral Commission. And in it stated that, once again, elections were going to be done with the pins. So, they released something to the class reps. Once again,
kindly let the court know the timeline.
Unfortunately, we actually do not have a copy of it here.
This was released by the Office of the Electoral Commissioner on the 6th of August, 2021. If you may proceed.
My lord, that will actually be an issue. Especially, my lord, if I can have a look at that, then we'll be able to collate issues. Especially, my lord, if you can just.
In subsequent court hearings, this wouldn't be allowed. If you are coming with your witness or evidences, make sure you have a personal copy. Don't come and rely on ours, please. Don't come and be taking pictures here, please.
My lord, Forgive us for that, my lord. That was actually one of the documents that we faced an issue gathering it at a very late hour. It's important. We are grateful for the cooperation of the court. My lord, if you look at Exhibit 122H, once again, my lord, that is actually a communique on the 3rd of August. And in this case, the EC states, my lord, and I read, if you can look at the bulleted point over there, the links and codes will be sent to official only US emails. Official only US emails. So, my lord, right from 31st August, 2nd to 2nd August, this was a PINS system that the EC was looking at. My lord, the last of it we will refer to is Exhibit 122D. 122D. My lord, this was actually, once again, an educational picture news outlet that the Electoral Commission released.
Sorry, Counsel, what you just read, what was it? Exhibit number
H. 122H. I stated 122H, my lord.
Okay, and you read that?
My lord, I read it from the bulleted point over there. I said
links and codes will be sent.
Links and codes.
So
Lord, are you okay, please?
Yes.
Thank you very much. The next point, my lord, that we are referring to, the last exhibit, my lord, we want you to take note of the inconsistencies. So for now, we have seen that the PIN codes was actually what they were planning on. Then the last exhibit, Exhibit 122D, the P target one, says that, my lord, you can actually find the date because it was actually shared on a WhatsApp platform. The date of it was not stipulated in the news outlet that the EC released, which is unfortunate. But the timing that it was shared is the evidence we only prove it out there to you. So, my lord, that was actually what they said was that we are going to input index number and portal password. My lord, this was 5th August. My lord, just a day before the elections. So the EC had planned with login, just a day before the election, they go with passwords. My lord, it is indeed true. And let me just read into the minds of my respondents, because I know what they will actually say about that. That they are working with stakeholders who also keeps coming in. I'm talking about the aspirants who keep coming in with their issues. And my lord, when an electoral commissioner shows consistency from the beginning, it is as best as the people it works with. The inconsistency started with the CI and it's round through. My lord, I will tell you how this contributed to making the credibility of the voting software null and void. My lord, what happened was that when a voting software developer starts to plan for elections, the passcode of the elections are mounted. My lord, these passcodes is what will actually allow voters to access the portal logins. My lord, these passcodes are actually lined up against each index number on the voter registration book that every individual must have a PIN. My lord, on 5th August, a few hours before the election, when it was changed, it means that the voting software developer had to actually change all those pins that has been mounted and then start to use the portal password of every student and mount it on the system.
If I may, are you speaking this because you were told by the software developer, or you are just making assumptions?
My lord, I am making clear insinuations from events.
Insinuations?
Yes. My lord, what I am saying.
Did you just say insinuation?
My lord, forgive me for that. The point I'm making is that I'm inference from the point.
Inference.
Yes.
So based on personal assumptions.
My lord, it's not personal assumption. It is the facts of
that's the fact
in election.
So the software developer told you he has to change all these PIN codes to whatever.
My lord, then we will probably leave that for cross-examination when the respondent will tell us on what basis
those
things were there. I thank you for the cooperation of my lords in that. You have read into the future. My lord, what the fact of the issue is that for you to have changed that system a night before the elections, that means that you needed to create a new room for another system. My lord, it is of this I submit to the respondent that this created numerous inconsistencies in the sense that it came into the elections and we realized that some PIN codes, as you could have seen, and the court used it to prove in a case, 111 was able to open the portal passwords of some individuals. It means that the pins that were actually mounted, changing it into the portal password became an issue. So it means that some of the pins were still active. My lords, this is what we submit. My lords, we will just move on and get an issue with verification. My lords, the inconsistencies move on with verification. My lord, what happens in an electoral system verification is that the conditions in which you set for the verification must be the same as what happens on the voting day. My lords, what I'm saying is that in the voting day, you need an index number and a password, a portal password in this case. My lord, for somebody to be able to be verified by a competent process, it means that there should be a system that checks both the index number and, in a way, creates a system to check the passwords. My lord, what happened was that we had a verification process that only used index numbers. My lord, let me just refer you to the national voting system. When you go there to verify, not only does the exhibition officer takes you through your names on the voter register. Afterwards, what they do is that they check your biometric information. That is actually your password to vote. So, my lord, the conditions that are present in elections must also be present in verification. What happens is that you leave the verification center knowing that, number one, your name is in the voter register, and two, your index number has been captured, giving you a passcode to vote. So you are very, very without doubt that this is a system that will pass you to vote. My lord, when the EC released a system that used only the index number, what it meant was that, yes, they had passed students, they have actually passed students on the voter register, but there is no system to actually indicate the parts of your portal passwords, the passage of your portal passwords. There is no system. My lord, it is of these inconsistencies in the verification that we found issues with portal passwords, because it means that we have not actually verified the passwords at the verification stage. My lord, at this stage, a lot have actually been established in the first issues, as competently done by the court when we found out that the voting software is compromised and insecure. But my lord, there are 3 videos here that shows one name that whose portal has actually been opened on some 3 circumstances. My lord, we actually have 2. And we realized that the information that the other cases showed presented another evidence to us. My lord, with the permission of the court, can we give an instance where one Linda Kujo, her details or her login platform was actually entered into on 3 separate occasions with different passwords and different index numbers. My lord, if you get me, or should I take it again?
You should.
You get me?
Take it again, please.
Let me take it again. My lord, one Linda Kujo, her portal login was accessed on 3 different occasions. You will just allow us to show it to the court. And on these 3 different occasions, what I'm saying is that we have a different individual, myself, Emmanuel Kabnabuatin, I have an index number, a different index number. I push it in there, I put my password, and it opens to the another person Adjourmancer uses an index number, puts the password in there, and it opens to Linda Kudu. Another third person puts the index number, puts in the password there, and it opens to Linda Kudu. My Lord, you have established a lot of things. Can we actually show the court what
we are not getting it, please.
Okay, so my Lord, then we will proceed to show the evidence for the benefit of the court. My Lord, for the benefit,
are we going back to Ms. Marchin again?
My Lord, maybe perhaps instead it's when sometimes I'll let my petitioner try and explain it.
No, please.
All right. So
I want to know, is it an issue of mismatch? If it's an issue of mismatch, I think we did due diligence to it. Yes.
My Lord, that's what I'm saying, that we have seen 3 videos.
Yes.
My Lord, you have established mismatching. All I'm saying is that we also have even a bigger evidence that points to one Linda Kudu, whose names actually came forth, and it tells you that because the passwords were not verified, one way somehow when the system was compromised, index numbers keeps on actually going on to the portal, to that particular login page of Linda Kudu. My Lord, we'll move on to elections should be free and fair. My Lord, if all this is understood, this is the reason why we are here. That when I wake up in the morning and I pick up my phone and I vote, my Lord, that particular vote should be between myself and the Electoral Commission and nobody else. That I will know that my vote has counted. It is this process that is defined by the Constitution as secret ballot. Well, let's look at some articles. My Lord, I don't know whether you have the PNDC law there. PNDC law 284 of the 1992 Constitution. My Lord, before we go into that, it is important that we actually see in the early part of the article that our Constitution also falls under the lawyer laws of the land, which is the Constitution of Ghana. I think my laws understand that. So if I can quote the PNDC law and make a point with that.
Sure, go ahead.
Thank you for the cooperation of the court, my Lord. My Lord, this is law 284, schedule 20. Clause B.
Quote the law, the article again.
And we are saying PNDC law 284 of the 1992 Constitution. Schedule 20, section 20. Thank you very much. Clause B. So, my Lord, that talks about grounds for cancelling an election.
Yes. Counsel, you have 5 minutes more, please.
Okay, thank you, my Lord. So my Lord, we'll come to that. The network is affecting us. We'll come to that, my Lord. My Lord, when we get that, it's very, very important. My Lord, our article actually gives credence to that particular provisions. My Lord, you have it?
Yes, I have it.
Oh, wow.
I want the specific.
Okay, so my Lord, that would be schedule 20 clause B. Schedule 20 clause B. Yes, my Lord.
Okay.
Thank you very much.
I read it to the court.
Yes.
Section 20, grounds for cancelling election results.
Okay, grounds for cancelling and election results.
1B,
Okay.
that there has been a non-compliance with any provisions of the law or regulations made under the law, that it appears that the election was not conducted in accordance with the principles laid down by the law, and such that non-compliance affected the results of the election.
My lord, that is the law of Ghana, 1992, the constitution of which this country is being governed on. My lord, it says that in any elections, if we do not go by the provisions of the constitution, there's grounds for cancelling the election. My lord, when the EC went with the constitutional document, the CI, if it didn't go with the CI force within the SRC constitution, which also falls under the 1992, but if it doesn't go by such provisions, legally, there is grounds for cancelling an election. My lord, then you will help me to refer to Article 37, Clause 2. My lord, Article 37, Clause 2 in our SRC constitution, please. Article 37, Clause 2. So, my lord, I'm already there, if I may read. My lord, it says that the election of executive officers shall be on terms of secret popular vote. My lord, I would like to end there. My lord, then I will take it to a notch further. 1992 Constitution, once again, Article 49 Clause 1. The 1992 Constitution, Article 49 Clause 1. So the first one was the PNDC law, my lord, which is also under the 1992 Constitution. This one is the 1992 Constitution, Article 49 Clause 1. My lord, I read. At any public election or referendum, voting shall be by secret ballot. My lord, secret ballot is the fact that when I enter into my portal lobby, nobody should be able to enter into that lobby. My lord, on this basis, our constitution makes it clear that the elections that we held must be annulled. My lord, on this, I rest in my introduction.
Please order. Young man, please. This is a courtroom. We are not in a prayer center. Please. If you want to clap, kindly leave the court and go and clap outside and come back, please. It's now the time for the opening statement from the EC.
My Lord, I would like to thank the petitioners for giving us the opportunity to go through the documents they sent to us.
But before you proceed, know that you have 12 minutes. 12 minutes to make yourself.
Okay, so my 12 minutes to make a statement. So to start with, I'll start with the PNDC Law 284 of 1992 Constitution Section 20. That he talked about the non-compliance to the law. But he actually didn't link it to any non-compliance. He just quoted it and left it that way. But he made mention of secret ballot. And he defines secret ballot as when a student is able to open the portal, no other person is able to open the portal. That's what he defines secret ballot as. But when we check secret ballot from the Oxford,
he defined it being able to log into your portal and voting without.
No, he didn't add voting please to it. He said someone open your portal and that person also has access to your portal. He didn't add voting to it. He didn't add voting to the statement. So when he defines secret ballot is also known as Australian ballot or Massachusetts ballot. It's a voting method in which voters' choice in an election or a referendum is anonymous. It's so someone opening your portal or having access to your portal does not allow the person to know what you have already voted for. So if I've already voted and you enter and they say that I have already voted, or you have access to the platform again to vote, it doesn't show you who I voted for previously. So then, getting access to my portal does not breach what is called by secret ballot, which he has quoted the PNDC law 284 and the section 37 of SRC constitution. It doesn't show anything. It means that his defense for secret ballot for which he's standing his grounds on is flawed. And he doesn't understand what secret ballot is. So if 20 people are able to open into my portal, but each of them is not able to see their previous voting, which he doesn't have any evidence to prove that when they opened the portal and another person had access, he saw that the first person who voted has voted for A. So sorry,
Please,
opening
the comments from the back.
So with my opening statement, sorry, Council. I'll start by reading the CI, section 13, which is voting process. The electronic casting the documents I have
It's 12 here.
is 13 also here. The storm is polling station, polling agent, voting process.
Polling agents, it's 11.
Here, electoral officers is 11.
So I saying we have two different documents or what? Because the CI presented to us and the CI you have as the ECR, if there are two different things, you should let us know. Let's compare with the first. Yeah. The first one is the second one is right. Where's the code? Where's the three code? There's no three, there's no four. It's the same. Okay, so after our check, we verified that they are the same document, just that we have So you quote the title so that we know which one you are referring to.
Yeah. So the voting process. The electronic online casting system should be used since it has proven to be effective in the immediate past SRC election. Yes, people raise an allegation, and whoever raised an allegation bears the burden of proof. And since last year election, no one has been able to prove that the electoral system we used for the last year election was flawed or had issues with. And this case has been sent to court and they couldn't prove and has been thrown out. And since the court does not deal with allegation but fact, then anyone who makes an assumption based on this allegation that the system is flawed based on previous election does not hold, because the election there was no proof, and when the people were called, they couldn't prove it beyond doubt. So in the court of law, anything that is not proved beyond doubt and accepted and being passed as a law does not hold as a ground for which another person should stand on and use as a form of evidence or a fact in the court of law. Also, the electoral commissioner made a commission. The electoral commission made use of pins and portal passwords, made use of to generate pins for each student using portal login information. So someone asked, what is portal login information? So if you log into it, when you put UHAS portal in your Gmail and it opens and they tell you choose UHAS portal, what information do you see? Index number and password. So anyone, if you are saying that you are using portal login information, then what are we asking or what are we using? It's portal password and the student index number. Those are the portal login. So if they use the word PIN, they said they will use a PIN generate portal password and login. So portal password in our UHAS platform is the student ID and the student password. And that is what the Electoral Commission made use of it during the election. So we have series of change or series of communique from the Electoral Commission talking about various information about a change. Last year, there was an issue with the Sandwich students voting. And they had issue because they didn't have access to voting. So they raised a concern when their issue rose up that we should use student email to vote. And since the Sandwich students form part of UHAS, their plea should be listened to. So their plea was listened to. After met together, a memorandum of understanding was made that let us make use of the UHAS password and the student ID, which I have submitted as a bit of the memorandum of understanding, which was agreed on 5th of August. So if a communique was also issued on the 5th of August into that effect, then I don't know if there's any inconsistency with this issue. Also, people may say that, okay, you have access to the password and there were changes in this access to password and other things. I asked a question. We have seen several exhibits here today that people are using 111 to vote, but we were able to prove that voting was not done. So then, saying that the password were changed and that led to the student having access or not using the student index number. For instance, I use my index number and my portal password, and I opened and I voted. And most students who were able to vote and cast their vote use that. And the court today has proven that those students who used a different code they generated couldn't vote. So it means that the portal password that the EC ensured that this will allow students to vote was actually used to cast the vote. And no one who has been to the court today has proven that anyone who used a different password was able to cast the vote. So if able to use I as an example, use my student index number and my portal password to vote. And those who are not able to prove that, it means that all votes that came in for the election were students who used their portal password and PIN, portal password and the index number. So then, this does not go on to say that the election was not fair and then it should be annulled. Yes, we agree. Yes, there's a proof that there was a breach, but the voting has been protected by the student password, the student ID. So I know that with my opening statement, talking about the secret ballot, what it stands for, also making known that there was allegation which was never proven, that this software that we used last year was proven to be flawed. And also talking about use of the pins where the electoral commissioner used shows the consistency of his communique to the people. And he has been fair to people as he sent the communiques timely for people to have access to it. So I thank you very much, my lord and my ladyship. Thank you.
So we now give room for the petitioner to cross-examine the defendant.
Thank you very much, my lord. And also, permission. May I call the defendant to the stand?
So I
Honorable Hubert,
do hereby in the name of Allah swear
do hereby in the name of Allah swear
that everything I shall say here
that everything I shall say here
shall be nothing but the truth.
shall be nothing but the truth.
So help me God.
So help me Allah.
You stated your name. Please, can you do that again?
All right. So,
Before that, you have 7 minutes to cross-examine. Please go straight to your point. The defendant has a right to not respond to any question. The counsel has a right to interject by objection. So please, 7 minutes. Go straight to the point.
Thank you, my lord. I wanted you to repeat your name and tell us who you are.
okay. My name is Honorable Hubert Bati, and I'm the Electoral Commissioner.
You are the electoral commissioner of the SRC.
Go straight to the point. Please go straight to the point, please.
My lord,
Asking you a direct question. I don't see how you are this yes,
Respectfully, apologize to the counsel.
I apologize.
that's fine. You are the returning officer for this year's SRC elections. Is that true or not?
That is true.
Thank you very much. Honorable, what do you understand by the word credibility?
Okay, so credibility in view of is just simply efficiency. That is what I would tell you. So credibility is just synonymous to efficiency. And yes, that's what I was saying.
Okay, that's fine. But as students, we all make research, isn't it? That is the brief understanding that you have. With permission from the bench, will I give to the defendant Google platform to actually Google out what credibility is?
You have 7 minutes. You can do whatever you want in this 7 minutes, please.
My lords, thank you for giving me the permission to do whatever I want.
Does not imply do whatever you want.
Thank you, my lord. Honorable, credibility, we can look at it together by Google, is the quality of being trusted and believed in. What do you say to that?
That is your definition of credibility, my friend. And with all respect, literature has made us aware there are connotational and denotational meaning of whatever thing we are looking for. So my definition of credibility is my work, if I'm able to get it, irrespective of the part, but making sure trust is there. So the word efficiency is my own profession.
Thank you. I put a highlight on your use of words, but making sure trust is there. For the record, my lord. How do you understand trust?
All right. I don't know where you are. This is leading to. Okay, so in short, trust is, making people have hope, and with the hope they have in you, you put it into, let me put it like a secured hope. Let me put it that way. So having secured hope, as someone puts a hope in you, so you secure their hope. That is it.
Oh, I like it. You are very good. You use the word secured. The court has established that the voting software that you use was insecure and it was compromised. Does that point to insecurity?
Counsel, please. The court hasn't clearly stated what you're saying. Don't mislead the court. Please, we haven't established all that you're saying. Don't mislead the court. We are yet to pronounce a verdict. So please, like I early on stated, anything we say here is on record. I don't want to be misquoted somewhere. Please. The bench hasn't stated what you are saying. So kindly, respectfully, retract what you said.
So, my lord, thank you very much for that. I retract that accordingly. Honorable.
Yes.
We have been able to ascertain the fact that a number of index number on the voting software, the portal login was mismatched. True or false? We've been able to see that.
That is very true.
Thank you very much. Does that mean that the software is secured by your understanding of security?
Perfect. We made it aware to the House that security, as per the destination it gets to, is when you are able to submit your vote. So as in, if someone should log into someone's portal without being able to access vote, that is not my definition of security. You understand, my brother?
I put it to you that for an individual to have been able to get access to another individual's portal login information, that is insecurity.
Like I said, this is your connotational meaning of insecurity, my brother.
Honorable.
Yes, sir.
With your position there, you know a lot about elections. True or false?
I don't know much about elections, but I think and I know that I can handle elections with all proficiency.
Honorable, you know of manual voting.
His name is not honorable, please. Can either go by his name or his office, please.
Thank you very much, Honorable. Thank you very much, my lord. Mr. Hubert, is that fine, sir?
Fine.
Thank you very much. Mr. Hubert, what do we mean by a ballot paper, when we talk of manual voting? What do we mean by that?
My lords, with all respect, can I ask my attorney to come in?
My lord, I ask the direct question, sir.
Your counsel can only come in when he objects and we sustain it. You can't ask the bench to allow it's the right of your attorney or your counsel to come in. So he raises an objection, we sustain, then he goes forward. So he has every right to raise an objection. Or better to ask anything, yes. He has every right, yes.
My lord, humbly, when these interjections come in, then you consider me on the 7 minutes. Humbly,
You have 1 minute, please.
So go ahead and answer the question. What is secret ballot?
Okay, so please, my attorney will attend to that. Thank you.
My lord,
You can't give it to your attorney to answer for you. He can only raise an objection to the question he has.
Okay, then I'll object.
No, you can choose not to answer, but you can't object to the question.
I'm sorry. I am new to this. With all respect, I'm new to this. Thank you.
Okay, I think your time is up, counsel for the petitioner. A bit of education here. Counsel, you may resume your seat, please. This goes to the two counsels. So in cross-examination, while your client is being questioned or examined, the counsel should be listening to the examination. The counsel has a right to object. If the bench deems it fit to sustain, we would, for you to make, your statement. So counsels, even as your clients are being examined, you need to be paying attention. A counsel can object and ask for clarification, relevance of questions, or whatsoever. The bench would either reject, that is overrule, or sustain. Am I making myself clear? I'm sure in the next cross-examination, this wouldn't repeat itself. Thank you.
We call.
My lord, I would like to call the petitioner to the witness box.
I, Philip Cosmos Bubunyo,
Do hereby in the name of God Almighty swear
do hereby in the name of God Almighty swear
that everything I shall say here
that everything I shall say here
shall be nothing but the truth.
shall be nothing but the truth.
So help me God.
So help me God.
Mr. Phillips, right?
Yes, you can call me that.
So I would like you to tell us the difference between allegation and the proving statement when it comes to the law court.
An allegation will be anything that's not founded in evidence, and a proving statement will have evidence backing it.
So I put it to you that last year election, where the issues raised against the software system were allegations.
I decline to answer that.
And you know that you can't base your assumption on allegations.
Yes.
So can you say that the system is proving to be flawed, used last year, based on allegation? Can we say the system was used to be flawed?
Please, I wasn't the person who took last year's case.
But in your petition, you made a statement that, based on a reference to last year's election, the EC made a statement that it was proving to be effective. and you made a statement that last year there were a lot of issues surrounding it. You made a case with that. So then I'm asking you, based on the allegation raised, does it make the election, the system to be used to be flawed?
Based on last year's allegation, is the system this year
It's
flawed?
a system because before the CI was written, it was based on evidence of last year's usage, not what happened. It's based on previous evidence. So then we are asking, you are saying that it was allegation is something which is not proved to be true, factually true. And all the circumstances people wrote in the book were allegations, or document were allegations. There were no substantial proof against it last year. And there was no court ruling showing that the software system was flawed. So I'm asking you the question now.
Counsel,
So please, can you say that the system used last year, before the election this year, was flawed?
last year's election system, I can't say it was flawed.
But you based your case on it that there were allegations, and that it doesn't lack the merit of which the EC put in the CI that is supposed to be effective.
Yes. Counsel, when your client is about answering questions, you can't object. Please. He was about to answer the question, then you are objecting. Sustain.
This is not responsible. It is possible in the sense that our argument in last year's election was that it didn't follow the total aspect, the CI that the DC got made mention of P, of which last year it didn't follow P, but rather it was a total aspect.
My Lord, if you check the voting process also in the CI, it may mention that PIN, which are portal information. And in my opening statement, I made that portal information. If anyone here type UHAS portal on Gmail, on mail, and it goes there, it says the portal information are the user ID, which is the student index number and the student portal password. So then I don't see the contradiction here between this and last year.
This never said the system was flawed. What he said was that there is inconsistencies.
To proceed.
Do you know that last year the sandwich had difficulty in voting?
I wasn't aware.
And you know that the sandwich are part of students of UHAS and should be, their vote matters.
Yes.
So if they had issues voting last year, do you think their input is important when it comes to this year's voting?
Yes.
So do you know why there was a change from using the email, the email to the portal password? It was a memorandum of sign on the 5th of August. Do you know the reason why there was a change?
No.
Did you seek for clarification why there was a change?
No.
So you didn't seek clarification why there was a change, but in your opening statement, your counsel made mention that all these things were changed and this caused a change in portal password. I want to ask, you brought exhibits to show that 3 different people, there's a name Linda something. I wanted to know, when you opened the portal, did you get to see what the previous person voted for?
No.
So this can see that even if 4 or 5 people open the portal, you can't see what the previous person voted for.
But that wasn't the argument.
Oh, we're talking about secret ballot, so he even went to PNDC law 2824 overruled. Because he went to PNDC law 284 to code secret ballot as part of it. That Linda had 3 people open it, and that does not show secret ballot. But I'm asking, you said no. You couldn't know what the previous person voted for. And I'm asking a question. That because you don't know what the previous person voted for, does it go against what secret ballot means?
No, it doesn't.
But if before you answer the no, what is secret ballot?
Sustain.
About this is a really good question. The previous question was that he doesn't know anything of that. My Lord, counsel want to go on and teach where's out of life.
My Lord, I asked him a question saying that when he opened the portal of Linda, did he get to know whether what the previous person voted for is showing? And he said no. And I said, does that disprove or does that break the code of secret ballot? And he said no. And I'm asking, I want to know what he actually knows was secret ballot. Before he answered the question, I want to know his knowledge on secret ballot. He said no. Your petition is here, so let him answer for himself.
What was your answer? I did say no. No.
He said no.
Overruled.
Counsel, kindly pay attention to what your client says. Don't mislead the court.
I would like to know, were you able to vote in this election?
Yes.
Did you verify?
Yes.
You verified.
Yes.
And when you verified, was your name and picture and index number there?
Yes.
So you're ready to verify.
Yes.
Now the people that you bought their exhibits, did they verify?
I have no idea.
So you don't know whether they verified because it was a communique that when you verify and the information there is not yours, you should make it known to the EC that the information there is not mine for a correction to be made. But this person you are saying, open the portal on the day of election to find out that it's a different person. Wait, I'm coming. I found the question. It's a different person. It means that on the verification day, either the person did not verify, or when the person verified,
They verified their index numbers alone.
and when you verify the
Most
index
problems
number,
were with the password.
so when you verify the index number, your picture and your name, everything shows.
Yes, but most problems were with the password, not the pictures.
So when I open a platform, now do you know that when I have my email and I input a wrong email and I input a correct password, the portal is not supposed to open.
And the same is vice versa too. If you input the right email.
So then
wrong
don't say
password,
that
so-
the main problem was the PIN.
No, people's problem they were encountering was they said PIN. When they changed their PIN, it came.
When they changed it, it came.
That's when they used the PIN, the 111 PIN.
So I was asking them, did they verify?
No.
So they didn't verify. And if they had verified and it was their name and index number, and on a voting day, they opened the link and it was not theirs, then they had a case to raise. Cancel. Arrest my case. My lord, arrest my case.
Okay. Have you submitted your witness? Oh yeah. Have you submitted witness? You submit your witness, or you don't have witness? Okay. So the counsel for the petitioner has submitted order in court. The counsel for the petitioner has submitted a list for witnesses to be cross-examined. So, counsel, would you still like to proceed to cross-examine the witnesses you have put forth to the court?
I would still like to do that.
Okay, so call your witnesses. 5 minutes. I see 2 names here.
So now, the first on the list is the Electoral Commissioner.
Okay, so he has been. Yeah, so okay, so you have 1 person. So
No, my lord, I still want to proceed to call the Electoral Commissioner.
again,
Yes, as my right for the witness.
Objection, my lord.
you've given the opportunity to cross-examine him, so he can't be a witness again in your.
My lord, thank you very much. But cross-examination would definitely have to be you cross-examining the defendant if you are the petitioner. But the witness to a statement depends on what this side of the court of the petitioner says it will help our case.
But here he's the defendant, and you had the opportunity to cross-examine him.
Yes.
So whatever type of questions you had for him would have been met with the initial cross-examination as a witness, because you are building a case and you had the opportunity to cross-examine the defendant. Here, he's not anybody in the crowd we can call. He's a defendant, and defendants are given opportunity to be cross-examined. Once that is done, you cannot call him back as a witness to the stand.
My lord, cross-examination and witnessing establishes different things. And it makes the, my lord, I will indulge your cooperation that I want to use my one witness for the electoral commission.
You have a right to a witness. You can call anybody to be in the witness box to serve as your witness and cross-examine. In this case, the EC is the defendant. You've already cross-examined him. He can't be a witness. Okay? Are we on the same page? You had a chance in your opening statement. You had a chance to call the defendant to cross-examine him. We are giving you another chance to cross-examine your witness. The defendant can be your witness. You have two witnesses here. One, Mr. Paula Prince, and the EC. We are striking out the EC and giving you the go-ahead to cross-examine witness number one. Please.
And with respect to the cross-examining of the witness, the defendant, the counsel for the defendant will also have to cross-examine the witness. So are you trying to say that the counsel for the defendant must cross-examine his own counsel?
My lord,
So
we take your directions in good faith. My lord, we respectfully like to submit that based on that anomaly, we would like to actually make an edit in a very soon.
Bring on board another witness. You already have one here.
Yes, my lord. But we didn't know that this is the tangent of my lord. My lord, respectfully, we want to look at that and get one witness as you can see. We actually thought it.
You have two witnesses. So just cross-examine the other one.
My lord, we thought it would be two. So based on what you are telling us, it's a new.
the court has already stated that assumptions and thoughts cannot be put across. This is what you are dealing with the law here. So it is static and statutory. So you cannot come and say you thought. Not knowing is not an excuse. So if you put forward a witness, two witnesses, and it has been found out that the court cannot allow you to cross-examine one of them, you just move to the other one you have on the list, then we move on. It is not our fault. It is on your part not knowing. So we cannot.
With a new output from you, we have to respond. We are saying
This is not a new output. Counsel, you should know this before you come to court.
my lord, we are asking that can
You can't replace your witness. You brought forth two witnesses. One can be cross-examined. Kindly move ahead and cross-examine the other one. Thank you.
Thank you for the book. My lord, unfortunately, our witness had an issue with diarrhea. And then he had to actually leave us so soon. My lord, in this case, we plead with the court. What is the way forward?
And we proceed without cross-examining because the counsel for the defendant has not put forth a list of witnesses to cross-examine. So since you have no witnesses to examine, so you cannot, we will not be able to allow you to have another witness after submitting the initial witness list. You can't make amendments to the initial one. So we proceed to the next. Yes, so we will have questions from the bench to both the defendant and the petitioner. Counsel. You can resume your seat.
Thank you, my lord.
Okay, to the petitioner. I think your last but one, let's call it a paragraph. Yeah, it's a paragraph. We have reason to believe that changing of this PIN password procedure created room for the voting software to be manipulated. Again, we have evidence to prove to your high office that the portal password used in the election was unfortunately and effectively breached. My concern has got to do with the first sentence. We have reasons to believe that the changing of this PIN password procedure created room for the voting software to be manipulated. Can you please convince the court as to why you are having this belief?
Thank you very much, my lord. My lord, whenever you start off with a plan,
Can you please be outstanding?
my lord, when you start off planning of something and you know that this is what you want to do, my lord, when you have a plan, you have a means to get in there. My lord, when you begin to change things along the way, it actually leads to breaks. My lord, what we are saying is that they started planning off with pins for us an access to get voters to the portals to vote. My lord, the point is that these pins have to be lodged on a system against every index
Counsel
number.
for the petitioner, thinking this is the purview of the software developer. For that matter, you can't comment on this. As to how the software developer programs the software, you and I are not the experts in his field. So maybe we should leave that to him.
Lord, indeed, as you said, technicalities. But the issue of it is that I am making a fair statement on what actually needs to be done.
No, we are making bad assumptions. We don't work on assumptions in this court.
No, my lord, I'm not making.
You are not an expert in this case. So let's not dwell on assumptions or inferences.
My lord, the truth of it is that you cannot say that because we are not technological experts, so we cannot speak of even the basics of issues when it comes to these things.
These are not basics.
Unless, my lord, you are judging these things not to be basic. My lord, what I'm saying is that before you can get pins into the system, you have to put them there. My lord, this is my
That is your assumption.
This is what I'm putting forth.
Or this is your thought.
My lord, when we were preparing for this case, we had the opportunity to actually speak to experts.
And you didn't think it was prudent to bring him as a witness to help in your case?
My lord, unfortunately, our expert is not in here as we speak. He gave us due diligences and then documents on matters. My lord, what we are saying, as I am respectfully putting out there, is that before you can use the pins, you must put them in the system.
He told you that? He told you that? He told you that?
My lord, yes.
He told you that? The software developer told you that?
An expert from the National
The software developer of this voting software told you that?
No, my lord. My lord,
then let's not base on what someone told you. Go on.
Oh, my lord, I can definitely not get this information from the software developer.
Now, when it comes to software development, there are algorithms that are used to develop the software. For every developer has his own way of development. So you can't stand here and state categorically that one expert told you that you log in with pins, you add the pins, or what did you say again? You place the pins into the system, right? Yes. So what shows that the software developer in question used a different algorithm to develop his software and does not need him to put in pins as you are stating, because software development is quite a broad area and you cannot say with specificity that this is a particular way all softwares are developed or designed. Do you attest to that fact?
My lord, I understand you. My lord, what I'm saying is that definitely there needs to be an undoing of whatever they were planning for. Because they looked at things later and nights before the elections, it was changed to passwords. My lord, we are actually putting forth that the software developer, the technical research that we made needed to do something. My lord, the issue is that what does he have to do? I think that's
all right.
what I wanted to get into. But my lord, my lord, if I may respectfully learn, my lord, if he then had to do something from
something means
that you plan for PIN, and now you have to change it to portal passwords. My lord, these are different information.
So if I may kindly resume your seat.
Thank you very much.
Can you be abstinent easy? Prior to the changing, was there any agreement by yourself and the candidate or the stakeholders to go by the PIN?
Yes, please. So,
a follow-up question: was it consented to?
Yes.
So you and the candidate, the major stakeholders, consented to the fact that you would want to use PIN.
Okay.
I want a simple yes or no answer. You can let your counsel come in.
My lord, please the question again.
Okay, I'm asking. There are two things here. Petitioners are raising a case that the changing from PIN to password was with a motive which I can't say. Prior to the agreement on the PIN, what happened?
Okay. So the EC, together with the stakeholders, made an initial decision of using PINs and an email.
And when you have any document to this regard? Okay, so you all agreed to using PIN.
So initially they agreed to using the PIN.
Can you give us timeline, date?
Do you have the agreement ready?
So the meeting, the second meeting where the agreement was made for the PINs was on Zoom. And the Zoom meeting was held on July 18, 4:08 p.m. That's when the link was sent. And the meeting was scheduled for 7 p.m.
7 p.m.
Yeah, 7 p.m. on July 18th. So July 18th,
Sure.
meeting scheduled for 7 p.m. A Zoom meeting.
My lord, so there was an agreement to the usage of the PIN. What changed the portal password? I have your MOU here on the 5th of August, where the EC, the candidates for the 2020-2021 SRC slash local NOS election, as well as Party C, who is the software developer, signed this MOU. What necessitated this one, please? Defendant.
Okay, so on July 18th, the agreement was made for using pins. But as the time unfolds, the aspirant decide that they do want to refer back to the use of the user and the portal password. So the aspirant made a case that yes, even though they made an agreement on July 18th to agree to the use of pins, but now they have considered that they want to go back and use the portal password and the student index number. So that's necessitated the MOU to be signed on 5th of August, stating that you're going to use an online system, and with the online system is going to be student ID and the portal password. So it was a case raised by the aspirant as the days unfold and drawing closer to the election.
So the candidates as well as the other two parties, Party A, Party B, agreed to this and they signed this MOU.
Yes,
To
please.
go into the election with the voting software being the online one, as well as the portal password and what the
Student portal ID or index number.
ID. It was well agreed on as seen in this MOU. So if I got you correct, it was changed from the pen to this form because of some which I had something.
All right. So it wasn't due to the sandwich student. It was the candidate. They wanted the choice. They voted on it.
So
That
the
they will use the
candidate
portal.
wanted the portal
Yes, please. They
password.
voted on it, please.
Voted.
Yes, please.
Okay. So I have here 12 candidates consenting to this voting mode or voting method. I think the clarification as to why it was changed from the PIN to the portal password has been made clear to the court. I don't know if anybody has another thread of doubt. My just my question to the petitioners. Verification. How different is verification from voting? You want your counsel to take this one? But did you verify? Kindly be outstanding. Hey, Anna. So let me take the question again.
My lord.
How different
My lord.
is
My lord, please, under normal circumstances, I need to also hear so that I can also guide in its answer.
okay? After the MOU to use the voting system, was there any objection by any candidate from the Ahoy campus?
No, please. No, please.
My Lord, on what basis is he saying there were no objections from Ahoy campus? My Lord, Ahoy campus didn't appear on that said meeting.
Counsel, respectfully, you are not called to talk. Don't talk.
Oh,
You are not cross-examining him. You can't cross-examine him right now. I'm doing my interrogation. Please.
my Lord, you are drawing a conclusion on that. If you can.
That is my conclusion, not yours. So don't dare question my conclusion, please. Respectfully.
My Lord, respectfully, can I respond to that? Because it was
I didn't ask you. I asked the EC. I've gotten my answer. I come to question my answer.
My Lord, I want to respond to the bench of which you are part.
We haven't asked your question. So what are you responding to? Have we asked your question? So what are you responding to? I mean, let's not do this. You can have your seat, please.
Yeah.
I have a concern, my Lord. Respectfully, I have a concern, my Lord.
Is there any candidate in court, please? 3 candidates. 4 candidates, actually. Okay. 5. 8.
My Lord, we have received a fresh case of something that we'd like to present to the court.
Counsel, I'm doing something and you're interjecting.
Sorry, my Lord.
Counsel, your attitude is becoming untoward. Don't push me to the wall, please.
So with regards to the MOU signed,
Would like the candidates to kindly stand up. Okay. Okay, so how do you like use it?
Kindly take your seat, please. Treasurer-elect, kindly be outstanding.
Treasurer-elect. Treasurer-elect. Here, treasurer-elect. Treasurer-elect. Treasurer. SRC treasurer.
Okay, kindly come forward.
So I swear that everything I shall say here shall be nothing but the truth.
Swear that everything I shall say here shall be nothing but the truth.
Regards to the MOU signed, the EC has made a statement that because of the inability of the Hawaii candidates to be present at the signing of the MOU, a decision was taken on your pages, on the page of the candidates. Do you have a page in the first page? Do you have a page of the candidates?
Yes, we do.
Yes. So a decision was taken there that all students from the Hawaii campus, the decision with regards to the MOU will be taken in their speed, true or false?
Please come again.
The question is, those at Hawaii were not present at the signing of the MOU. However, an agreement was made that whatever decision taken is they are in favor of. Was that agreed on your page?
Miss Gertrude Fanini, are you getting the question?
Ask whether we agreed on a page that
No. The question we are asking you is, was it agreed that the MOU is binding to even those who were not present?
so those of us who were present, we had our vote in physical. And those who were not present were asked to cast their vote on the page.
Can we get the votes which were cast on the page for the Hawaii squad? My second question, after this MOU, was there any objection from anybody, including those who signed?
I don't know those who signed, but some people did not object. Some candidates did not agree to it.
You didn't agree. How many were there?
I think about 2.
About 2. Do you have their names, please?
Yes. Honorable Eshbontin and Honorable Muru.
So aside these two people, any other person who objected on the page?
No,
So out of the, how many are you, the candidates?
I can't tell.
So let's say 21, 24. Isi, how many are you? How many were there, please? We have the vetting results. Wait. 24 candidates. Out of the 24, are we concluding that two people objected to the voting? Let's get to
Yes, yes, please.
Is that the case?
Yes, please.
So, so if you can resume your seat. Honorable Moro and Honorable Esbontin, please approach the bench. So,
So I do hereby in the name of God, Allah swear,
Do hereby in the name of Allah swear
that everything I shall say here shall be nothing but the truth.
that everything I shall say here shall be nothing but the truth.
So help me God.
So help me God.
so, thank you. So the question here is that you, aside the two of you, is it, are you attesting to the fact that both of you made objections to the provisions of the MOU?
Yes.
Exactly. So aside the two of you, were there any people who were open to the objection of the MOU? Aside the two of you, just answer yes or no. Aside the two
As
of
in
you,
people who are open.
yes, the candidates on the page that objected to the MOU. Aside the two of you,
Not that I know.
just the two of you, I presume. Please, you can resume your seat. Thank you. Please, no, please kindly resume your seat.
We don't know the MOU they are talking about.
The MOU signed on the 5th August.
We need to see that in documents. There was no document presented to us for us to sign. What we signed, we categorically asked why we are signing. He said it is an attendance sheet. The electoral commissioner said we asked that is it an MOU? They said no. Honorable Elijah is here, federal SRC candidate. We asked categorically, is that an MOU? They told us no. It's an attendance sheet.
You kindly resume your seat. Thank you. You have some. Cancel.
rebutted. I didn't see the objection. So with that may establish by the bench that out of the 24 aspirants for the out of the 24, two persons were known to object to the memorandum of understanding. That has to do with using the portals as the means of voting. So that means it takes that more than majority of the aspirants agreed to the MOU that we are going to use the portals for the elections. I think with this, counsel for the petition, kindly give your closing remarks.
2 minutes.
My Lord, we proceed to make our statement, our closing remarks as such. My Lord, that the secret ballot as enshrined in the Constitution, which was read to us by PNDC Law 284, Schedule 20, subsection B, states that if the EC does not comply to its own regulations, the elections must be cancelled. My Lord, there is credence to Article 37, Clause 2 in our Constitution that the basis for a free and fair election must be that there must be a secret ballot. My Lord, a secret ballot is that
when I have my voting document, nobody to see it. That is a secret ballot. And this has not been established by the Electoral Commission whether there was a breach, or we have established that indeed there was a breach.
My Lord, they made mention of using pins, but a pin is a personal identification number. A pin does not include letters. So initially, I still submit to them that in the CI, when they say pins, pin is a personal identification number that does not include alphabet or whatever. But we know that portals have alphabets. So that was not what they were looking at. They actually came back to change their pins into portal passes. My Lord, again, an allegation has been made that the EC did not actually be in good faith regarding the memorandum of understanding. That what they signed was actually an attendance list. Unfortunately, my Lord, we didn't actually get observers to actually attend to this. Finally, my Lord,
Counsel, take your seat, please. Counsel for the defendant. Closing remarks.
My Lord, my closing remarks, please. The petitioner, from the Article 37 of secret ballot clause 2, could not be proven by the petitioner that any of the persons that had access to different portals saw the elections or saw the voting of a previous one. So then the issue of secret ballot was never broken, and this does not infringe on the SRC Article 37 clause 2. And also, the CI stated that the use of pins, which contains that the Electoral Commissioner generates a pin for each then using portal login, which you have made to know that portal logins are the student ID and the student password, portal password. So portal pin, they're still generating a pin for you. That's not bind. It's not bind because this time they're going to use the portal password to generate a pin for you. And also, there is no proof before this court that the software system used the previous year was flawed, and hence their argument, I pray the court should be struck out. You know, I think that the EC has been fair in this election in considering the views of the aspirants and subjecting them to the vote, and which the majority won. So EC has been fair in delivering his service to the people, which are the aspirants. Thank you.
okay. So, thank you. We shall proceed to hear the next case. You can resume your seats.
Mr. Subantin, kindly leave the bench, please. We have our last case for today's hearing, and it's like the fielding parties are not even around. Clerk, as you may.
Case 4, Mr. Emmanuel Pavna Boatin, PO Box TA322, GA04527026, Haifa, Accra. The Chief Justice, U.S. SRC, Ho, 6 August 2021. Dear Sir, suit against the Electoral Commission. I write as a concerned student and a veteran committee member of this year's SRC election that is slated for 6 August, that was later for 6 August 2021. To start with, this petition takes its basis on my request to the chair of the vetting committee, who constitutionally happens to be the Electoral Commissioner of our SRC. Your noble office was duly copied in this petition. In this regard, we petition that the issues surrounding the aspirant, Mr. Prosper Kome Oblite, GPA, should be thoroughly investigated and that the EC comes clear on the documents the aspirant submitted to the vetting panel. Secondly, Your Honor, it should be noted that the federal presidential and vice presidential aspirants take one form as a team. Any issues arising from the vice part affect the president and vice versa. Thirdly, attached to our petition is a letter released by the Electoral Commission on the resignation of the same aspirant. In this letter, the aspirant stated clearly in his wishes that the EC allows Mr. Rudolph to contest alone. Unfortunately, sir, this has implications that undermines the provisions of our Constitution. Article 18 of our Constitution reads, there shall be 5 federal executive officers to wit, the President, Secretary, and Treasurer, Women's Commissioner, elected under this Constitution, and the Vice President. Your Honor, this clearly makes the position of the Vice President one that should be duly elected along the ticket of the President as well. It must be noted that the position of the second gentleman of our SRC, who replaces the President in his absence on all functions and assumes considerable powers under our Constitution, is not one to be left to the honors of appointment. Again, Schedule 2 of our Constitution talks about the presidential oath, of which the Vice President is pledged to swear to the people of Jihad as an elected federal executive. Lastly, the EC's acceptance of Mr. Oblite's resignation is a breach of its own CI on Article 8, subsection D, which states that a candidate cannot withdraw his or her candidature a week before the voting day. We hold the view that the other federal aspirants, provincial aspirants, and the local NIC aspirants have done no wrong on which the court should place an injunction on the whole election. We are asking your high office to take a note from a national precedent in 2016 when the Miss Charlotte Osei led EC withdrew the candidature of Mr. Hassan Ayariga from the elections until further investigations were concluded. This paved way for the electioneering process to continue smoothly. The conditions leading to his resignation must be investigated and the truth be made clear to the good people of UHAS whilst keeping the electioneering process active. This will be an efficient measure in these times of COVID, where the academic calendar is already affected. As the elections is slated from a few hours from now, the SRC constitution stands to be handed a major blow if Mr. Rudolph runs. Even if he is to select a new vice candidate, the process of vetting must be exhausted for Mr. Rudolph and his new vice before his candidacy for election can be secured. Based on the above premises, the following are the three prayers of the petitioner. 1. That the court holds the election until due investigations are made for a fair and smooth election. 2. The court compels the EC to submit all documents provided by Mr. Rudolph and his vice to the vetting panel and the due investigations conducted. 3. That any case of forgery or malpractice found also implicates Mr. Rudolph as an aid in the offense and hence makes their candidacy null and void. Your Honor, as a custodian of the law established in our Constitution, I have no doubt that your high office will do the needful to my petition, and the greatest sincerity will be accorded to the student community. I count on your cooperation. Emmanuel Kwabena Boateng, lead petitioner. Godwin Ejay, second petitioner. Thank you.
Do we have the petitioner here? Do you have any legal representation or you are here to represent yourself? Godwin Ejay. Is the AC around? Are you here with the legal aid or you are here on behalf of yourself? Kindly take your seat. I'm sure you know the routine by now. I'm sure you know the routine by now. Tender in your witnesses, tender in your evidences or your exhibits. We don't want a situation where we start the hearing and you are now submitting witnesses or evidences. Please, we shall not accept should that happen. Thank you. petitioner and defendant, are we good to go? Okay, are we good to go? Have you all turned in your evidences, your witnesses? Like I said earlier, if you start, we won't any additional subtraction. So, counsel for the petitioner, your opening statement, please.
My Lord, briefly, we submitted an application for an amendment. Especially, that is also part of the documents of which we tendered.
The bench has accepted the amendment of your prayers. The amendment which make this. So the application for amendment of prayers. I write to the court for official permission to amend the first prayer of my suit, which was submitted to your office on the 5th and subsequently received by your honor on the 6th August. This becomes necessary when your office directed me to make changes to the petition, now suit. In these cases, my prayer was changed from that the court lays an injunction on the candidacy of Mr. Rudolph in the election until necessary steps are taken whilst paving way for elections to continue. To that the court holds the election until due investigations are made for a fair and smooth election. However, this prayer is not valid any longer as the elections has been organized. We plead with the court to allow the following amendments. 1. The prayer number 2 and 3 becomes 1 and 2 respectively. And 2. The third prayer now becomes that the court orders for a rerun of the presidential elections of the approved candidate. It is our hope that the court will accord us with the highest cooperation. Thank you. The court hereby accepts the application for amendments of the prayers. So we proceed with your opening statements. 10 minutes for both of you.
You are most grateful, my Lord. My Lord, we are here tonight seeking justice in a matter we feel aggrieved in. My Lord, the background of the case is that on 5th August, 9:59 p.m., my Lord, we were actually vetted by the Parliamentary Vetting Committee. 2 of us were chosen to serve on the vetting committee. My Lord, actually, we were the 2 best candidates that the vetting committee of the Parliament found us competent enough to actually join the vetting committee to vet the substantive aspirants. My Lord, we started our vetting on 9 July around 3 p.m. We started vetting local news, provincial, and federal aspirants. My Lord, we actually took a decision to fail one Miss Precious on her GPA. My Lord, we say this because we use transcripts. Transcripts were submitted to the vetting committee, and it was based on this that the vetting committee did due diligence to have actually failed disqualified Miss Precious based on a CGPA. My Lord, this lays the premise that the vetting committee has a track record of fairness and that every transcript that we actually inspected, we made sure that we did justice to it. My Lord, it was unfortunate that allegations came up afterwards claiming that somebody's GPA is not up to. My Lord, as a stakeholder of the vetting committee, what I did was to actually petition the office of the EC chair, and I started that with a private communication with him. I asked him, Honorable, as a vetting committee member, and as all of us are in the vetting committee, this is allegation that I see, but I believe we did a good work. What is the, do we have evidence? Because we gathered all the on is wrong. Unfortunately, my lord, the EC chair never responded to me until I took the matter on that I needed to get the right clarifications. That is why we came to your office. My lord, the argument here is that according to the CI, my lord, let's look at Schedule 7, subsection 1C of the CI. My lord, Schedule 7, Section 7. Sorry, my lord. My lord, that would be right from the first section. Sorry, my lord, we'll come to section 7. So let's start with section 1. My lord, it talks about, we are looking at the CI of the EC. My lord, it talks about the eligibility criteria for aspirants. It moves down to, my lord, I'm looking at section 1. My lord, I duly stated, I will come to that. Thank you very much. My lord, you realize that the electionary process are coordinated. My lord, they are coordinated in the sense that you cannot leave one stage and come to the other. So the first thing is to do eligibility criteria for aspirants. And my lord, it states that the criteria is that, especially the C, section 1, subsection C, must have attained a CGPA of 3.0 in the case of an SRC executive position, or a CGPA of 2.5 in the case of a local news at the time of nominations. My lord, if you come to the nominations, this is what the Constitution has to say. My lord, it says that, my lord, I want to take it from the note. So it gives a lot of what goes on in terms of the nomination form. And most importantly, it talks about the third one, the note 3. My lord, an aspirant is expected to obtain 5 signatures. 5 signatures. That, my lord, if you look, what's that? 5 signatures from the, 2 from the executive board and 3 from the members of an association or institution in which he has held a position before to ensure section E and F of the eligibility criteria met. Candidates who have not met any position to obtain 2 signatures. The second one is that any aspirant will be required to sign the fourth one. An aspirant will be required to sign a consent letter to the academic affairs to enable the EC to procure their respective transfers. My lord, this is a stage before the vetting of aspirant. So the EC is mandated to actually get the transcript of aspirants, go through it, and make sure that in their office, what was said in section 1 is attended to, which is that the CGPA must be 3.0 before the vet process starts. My lord, when the vetting process started, indeed, they brought documents. The documents that they submitted, some was original and others came in photocopy. My lords, the case here is that the EC must have gone through all these documents at the nomination stage, approve it before the aspirants come in. But my lord, when the aspirants come in, that does not also prevent the vetting committee from taking a look. But my lord, it must be necessary to note that transcripts are a very sensitive document. My lord, it is so sensitive that it is only an aspirant who can give a consent for it. So it means that when the aspirant gives the consent to the EC for the EC to procure, the only person that can be able to determine what the right transcripts are is the EC. My lord, we looked into the transcripts that came in, and then we found an anomaly in the case of Miss Precious, and we realized that this was not the case. And my lord, we duly stated it aside. The case here is that the vetting committee looked at transcripts, and all transcripts were looked at in assessing candidates, and that if any transcript came that was not up to 3.0, we would have told the person. So the allegations must be investigated, and the EC must be able to provide answers based on the petition I presented. My Lord, the second case that I go to has to do with the part of the how confronted the electioneering processor. My Lord, it is so coordinated in the sense that if you do not meet the signatories in terms of your nomination forms, my Lord, it is null and void. What it means is that, my Lord, when a candidate is actually ready to become perhaps the SRC president, he goes in and must leave 10 signatures to back his document. My Lord, at any point, even if one of the signatures drop, his candidacy is invalid. This is how coordinated the systems are. My Lord, in the case of presidential nominations, the Constitution actually finds it very important. There are 2 columns for the forms, president and vice. So an issue affecting the vice definitely affect the president. So if in this case, Mr. Oblite, who was the alleged person, who, my lords, we are asking that the EC comes out and prove if indeed, and more practice is actually found against him, it nullifies the whole presidential form. My Lord, the third point that we are actually stating on is that indeed these irregularities actually continued in the election. Unfortunately, we were asking that the election be held. But my Lord, we're asking that these candidates be withdrawn. But my Lord, that didn't happen. My Lord, what happened was that the first time in the history of US, a candidate without a designated vice was made to actually contest in the election. My Lord, this was very unfortunate. My Lord, I quote Article 18, which gives credence to the fact that 5 federal executives must be elected under the Constitution. Who are the 5? It includes the vice president. The vice president is an elected office. My Lord, we didn't do justice to our laws of the SRC, and we went into an election without the office of the vice president being allocated to. My Lord, I said being allocated to because the DC released a resignation letter accepting the resignation of Mr. Oblite, who was the vice presidential candidate for Mr. Sunny Days. My Lord, he gave reasons as personal grounds. These were in the heat of the allegations. My Lord, when as a vetting committee member, I am asking my chair for answers, and he's not giving me answers. And all of a sudden, I just see him accepting resignation of the same individual who such an allegations have been leveled. My Lord, that is what has led me to you. My Lord, finally. Thank you, my Lord.
So with the Article 18 you quoted in the, I'd like us to take our Constitution and open to Article 18. It states that there shall be 5 federal executive officers. So with the President, Secretary, and Treasurer, Women's Commissioner, elected under this Constitution, and the Vice President. So it makes all the officers that have been listed before the elected were as the only officers, executive officers that are duly elected under the Constitution.
My Lord, this is a very good observation. But my Lord, I would then ask, then who are the 5 elected federal executives? If you can list them for me, I'll be very grateful.
Yes. It didn't say the provision, the law didn't say that there shall be 5 elected federal executives. It said there shall be 5 federal executive officers, not elected. You understand? There shall be 5 federal executive officers. So with the President, Secretary, Treasurer, Women's Commissioner, elected under this Constitution, and the Vice President. So it makes the Vice Presidency not an autonomous body that is elected under our Constitution.
My Lord,
the role of the CJ is to interpret the law. So if you are quoting the law and it's not well quoted, we have to really explain it so that you don't it doesn't come across as misleading.
My Lord, please, respectfully, I answer with Schedule 2 of the presidential oath. Schedule 2. It is actually stated. No, this is transitional provision. So, Schedule 2. My Lord, this is the presidential oath of our dear SRC. My Lord, so I, then your name, having been elected to the high office of federal, provincial president or vice president. My Lord, the vice president duly takes the presidential oath. Thank you very much. As an elected
Exactly,
officer.
he's elected, but he's not autonomous under the executive. So I'm not saying that he's not elected. What I'm saying is that you made the assertion that there are 5 elected federal SRC executives. But I want you to understand that there are only 4 elected executive officers that is for the federal. You get it? In your submission, in your opening statement, you made mention that there are 5 executives that are elected, 5 federal executives that are elected. And you mentioned the president, the women's commissioner, the treasurer, and the general secretary with the vice president. So these 5 people were the ones mentioned. And I am reading the law and I'm making you to understand that the Constitution clearly states that before the word elected are the people that the Constitution gives precedence that they are elected. So the word end is actually a separation from the elected. In as much as it is elected, it is not autonomous. He's elected, but it's not an autonomous executive with regards to the Committee of Federal Executives. You get what I'm saying?
He's elected, but not autonomous.
Exactly. So the people that were mentioned are autonomous executives. Autonomous in the sense that they stand alone. You get it? The vice and so there's a distinction between who the vice is. In as much as he's elected, he is not an autonomous member of the federal executive. He is a member, but he's an elected executive. But his role is not stipulated in the Constitution as those that are elected under the Constitution.
My Lord, thank you very much. My Lord, respectfully, I respond with PNDC Law 285 of the 1992 Constitution. Section 3, Clause 1. My Lord, I respectfully, my Lord, this is not a debate, but I am finding it difficult to understand what you are saying. That is why I respond. Counsel, PNDC Law 285 of the 1992 Constitution. If you can read that to the benefit of the court, I'll be most grateful.
Maybe you should read.
Okay, thank you very much. My Lord. My Lord, PNDC Law 285, Section 3. My Lord, Section 3, Clause 1. So Section 3, Subsection 1, Subsection. My Lord, this is of the 1992 Constitution. My Lord, it says from the prophet, no person shall be a candidate. No person shall be a candidate in a presidential elections unless he is nominated for election as president by a document which designates a person as vice president. My Lord, this is the laws of our Constitution. going into an election, the president nomination forms is the only form that designates the office of the vice president. Before somebody can become an elected president, the person must go through elections. Without an elected president, my lord,
on the
there is no
nomination
vice president.
form, he is a running mate. Don't make an assertion that he's a vice president. He's now a running mate. You understand? So don't say the provision to be elected to be a vice president. He's nominated as a running mate. So, in as much as the vice president is elected together with the president, in the Article 60 of the 1992 Constitution states clearly in clause 2 that a candidate for the office of vice president shall be designated by the candidate of the office of the president before the election of the president. It states it very clearly that election of the president, not both of them. In as much as both of them are together, it makes it autonomous, that it makes clear distinction who the election for. So in as much as he is elected with the president, he is not an autonomous body that you could say that when you were putting your Article 18, that there are 5 elected federal executive members. No, the vice president is not provided under our constitution in the under Article 60 and under Article 18 to be an elected officer. So let it be known to the courts here that in as much as the vice president is an elected officer, his candidature is tied with that of the presidency, and hence the election of an autonomous president gives credence to the vice presidency or the running mate as a member of an executive body. So please, in the quoting of the law, let us be very, very circumspect.
My lord,
there's a clear distinction and separation with an end.
My lord, if you agree with us that he's elected, then my lord, we can proceed.
Exactly.
We can proceed. He's an elected.
Yes.
So we can
retract
and so we'll go.
Retract saying that he is part of the 5 elected federal executives. He is not part.
He is elected in a presidential election.
This constitution is in tandem with the 1992 constitution.
Yes,
and I want to take the clause 4 of the Article 60 of the 1992 constitution. The headiness, the vice president and succession to the president. Clause 4. A candidate shall be deemed to be duly elected as vice president if the candidate who designated him as candidate for election to the office of vice president has been duly elected as president in accordance with the provisions of Article 63. Before election, he is just a designate or a nominee, a running mate. When you open your portal to vote, you don't see the picture of the vice president there.
My lord, respectfully, you are actually going into the details of the case, and this is actually on the defendant side.
Judicial
education
we are giving to all of us.
This is unheard of.
Relax. You quoted something from the Constitution, which you don't have to. You have every right, but when it comes to explanation, judicial education, the onus lies on us. You don't have a right. Who asked who and you? You and who? Who was that? Levels. Who asked you and who? I'm sorry. You quoted something from the Constitution and you are explaining. Your explanation seems to be misleading. As defenders of the Constitution, we can't sit aloof for you to mislead the court. We need to educate you, as well as all of us present here, on judicial matters. You don't have a right to come and quote and give explanation that is befitting you. No, you won't allow that. That is why we've opened
the 1992 Constitution. Keep on quoting the PNDC law, PNDC law. Yes, you have your right. But the supreme is the 1992 Constitution. This parts of the PNDC laws are in the Constitution. But I would have wished most of your preferences are from the 1992 Constitution. There's a whole lot of question marks on the PNDC law. Most of it have been revoked. Maybe you don't know. But I'm telling you.
My Lord, if any of them is revoked, you can please let me know. If PNDC law 285 is revoked, you can let me know.
I am saying that the ultimate for this court is the 1992 Constitution. Anything which is in our Constitution, which ultra vary to that of the 1992 Constitution, is null and void. The Constitution we are using says it clearly. The candidate shall be deemed to be duly elected as vice president if the candidate who designated him as candidate for election to the office of the vice president has been duly elected as president. The vice is not coming on his own.
My Lord, at this
It is
stage,
stated categorically in
respectfully, can we proceed?
If
Respectfully.
you continue to help me, I might be forced to sack you. I'm serious. When you are speaking, I give you the platform. So why do you keep on interjecting whenever I'm speaking? You want me to sack you from the court?
My Lord, I actually made a point.
You keep on interjecting anytime I'm speaking.
My Lord, if
Anytime
that is so,
you stand to
then
speak, I
sorry.
put down my mic.
Sorry
I don't
for
know
that.
why you keep on heckling me.
Sorry
The
for
next
that.
time this repeats, I'll be forced to sack you. And I'm serious. I'm serious. You can't come and quote something to mislead the court and expect us to sit alone and not do anything about it. You're supposed to be the protectors of this Constitution. We can't allow you to misinterpret it. No, we can't. And I keep on telling you that anything we do here is on record.
My Lord, respectfully, we can proceed. If it is agreed he is an elected person, we can proceed.
But he's not part of the 5 elected SRC executives, the 4 elected SRC executives. Case closed.
We proceed with the opening statement from the Council of the Defendant.
Can I, in your submission, I would have really wished if you didn't say this. You said it was rather unfortunate your petition wasn't taken. The truth of the matter is your petition got to me at 2:30. Meanwhile, the
My Lord,
previous night,
my Lord, please, I didn't
Can
say that. My Lord, you are actually giving
You
credence
said
of
it
a matter
it was
which
unfortunate.
it is not part
It
of my
was
petition.
unfortunate.
My Lord, you are saying something
Someone
that is
went-
different.
You said it was unfortunate someone, for the first time in the history of yours, someone went to you had SRC election without vice president. Let me tell you something. And maybe let me educate all of us. This is judicial education. You see, the court doesn't go around looking for cases. No, we won't do that. We are not police officers. And even with police officers, if you don't give them a hint, they won't come snooping their nose in your room. No. The court doesn't go around looking for cases. As of when your petition was in circulation, I was even the one who told you that, no, we don't do that. Because it hasn't gotten to my table yet. So why is it in circulation? That was the night before the day of the election. There were a lot of mistakes in your petition. I had to even correct it before you submitted the following.
Lord, you are making reference to something I didn't talk about.
Can I land? You said for the first time in the history of the House, someone was made to go for elections without a vice
My
president.
Lord, it's my case. It's my presentation. I allow the defendant to respond.
Relax. And you said it was unfortunate, meaning that the Judicial Committee sat aloof and did nothing. Meanwhile, your case came to the court on the day of election, 2:30. How do you expect us to give an injunction on an election?
My Lord, you are making a lot of inferences that I never said that.
No. So maybe you shouldn't have said that for the first time in the history of yours. Someone went, it wasn't like we are just sitting and look. If you don't bring the case to the court wouldn't, react to you. Maybe you should know this.
Well, it seems we are having a debate, which is unfortunate in the proceedings of the court.
Excuse me.
It seems we are having a debate, which is unfortunate in the proceedings of
Keep
the
on
court.
using the word unfortunate on the bench. The next time I hear the word unfortunate, I might be forced to sack people from court. Yes, I'm serious. Yes, I'm serious. I am being serious here. I'm letting you know that if you don't bring a case to the court will put a blind eye on any happenings.
So we take the opening statement from the Council of the Defendants. 10 minutes.
Thank you, my lord. So to begin with, I'll quote Article 37, Clause 1, which talks about elections of executive officers. A student shall not be a candidate in any election unless he is nominated for election as president, secretary, treasurer, or women commissioner by a document, and goes on to later signed by, so I want to end there, end of quote. Per this article, it does not recognize the vice president as a position for nomination, and hence not a candidate. Article 18 says that there shall be 5 federal executive officers, to wit, the president, secretary, treasurer, and the women's commissioner, elected under this constitution, and the vice president. The vice president is not a nominee as per Article 37, and hence not elected under Article 18. So now we should all be clear that the vice president is not a candidate and not a nominee based on Article 37, Clause 1 and Article 18. Now to continue, my lords, now it is clear that the president is not a nominee and hence not a candidate. So let's read Article 38, Clause 1. Article 38, Clause 1 says that a student shall not be qualified for election. And now we have agreed and have made that the vice president is not a nominee and is not qualified for election. So then the qualification here stating that a student shall be qualified by election to be an executive officer does not cover the vice president. And that's where the CGPA of 3.0 is. So that from the constitution, it is clearly stated that the vice president is not a nominee, not a candidate. Hence, the qualification to be a candidate for election does not affect him because he's not up for election. I want the host of the court to take this note. Then you go to my lords. What does the constitution about nomination? Schedule 7, Clause 1 talks about nomination. Schedule 7, Clause 1b, I quote, nomination shall be filed in respect of the post of executive officers to the SRC, to wit, the president, secretary, women commissioner, and treasurer. It goes back to buttress Article 37 and Article 18, saying that the vice president is not part of nomination based on Article 7.1b. I read again. Nomination shall be filed in respect of posts of executive officers to the SRC, to wit, president, secretary, women's commissioner, and treasurer. The nomination form of the president shall have a column for the name of the vice he or she intends to appoint in case of federal president who qualifies to be elected as an executive officer, provided that the president and the vice are not from one and same hostel. Then I'll take that same Schedule 7, Clause 2, and add it before I make my case. Qualification for the post of officers under the Constitution are contained in Chapter 6, which we read. Article 18 has made it clear that only 4 of the executive positions are elected for. Schedule 7, 1b also make it clear that nominations for only that 4. And Article 18 makes it clear that only that 4 are elected. Nowhere in these 3 articles in the schedule, the 2 articles in the schedule, stated emphatically that the vice president is elected. Now he's using the word elected, which I want to let him know that in the medical profession, if you talk about abortion, abortion is where you terminate pregnancy before the age of viability. And in Ghana, the age of viability is 28 weeks. In US, it's 24 weeks. In UK, it's 20 weeks. So abortion in 24 weeks is not abortion in UK. So, but when it comes to the Ghana law, when it comes to Section 58 of our Criminal Code at 29, it states that abortion is when you terminate the pregnancy before the end of gestation. And the the end of gestation in Ghana is 40 weeks. So the word abortion has a different meaning in one side and has a different meaning in another context. So the word elected does not mean that the vice president is voted on. So then on the form 2, it is written future president. There's no way stated future president and the vice. And it goes in the constitution. And there's a column created for the vice. And it fulfills the constitution. There's no way that the federal president and the vice go for one form So they don't pick one form. The form is written, the name is written future president and not future president and vice. So the vice is a position not voted for. My Lord, I continue. So Article 38 plus 1, a student shall not qualify for election of executive unless, and Article 18 and Schedule 7 have made it clear that the vice president portfolio is not elected under this constitution, and hence the whole Article 37 plus 1 does not apply to the vice president. My Lord, one may ask, what are the qualifications of the vice president then? Before this question is answered, we have to understand that although the vice president position is not elected under the constitution, he is an executive member when the aspirant who selected him wins the election. Under this constitution, he is an executive member by appointment as per Article 18 and Schedule 7(1)(b). With this in mind, my Lord, Article 38 clause 2 talks about qualification to be an executive officer. So this one cuts across all the 5, because it is stated that there are 5 federal executive officers, and these are qualifications for executive officers. That means at this point, the vice president is supposed to be here, because after he has been voted, his candidate, the candidate who's going for the president, after he wins, the running mate, the president, when the president wins, the running becomes a vice. So then he's supposed to subject to some qualification, and the qualification is stated in Article 38 clause 2, which talks about qualification of executive member. The clause 1 talks about the qualification of those who are to be elected, which I've already said. But the clause 2 talks about qualification of executive officer, which the vice president is a member because of his appointment by his candidate. But there is nothing in clause 2 of Article 38 that talks about CGPA. So CGPA of the vice president is immaterial when it comes to the qualification of the president. The qualification of the president is solely based on his or her credential. It's based on his or her credential for per the constitution. So, my Lord, as you have stated, to find out that in the constitution, the vice president is not a candidate. And they may say that the EC has written the CI that he shouldn't accept, he won't accept the resignation of a candidate. And we found out that the vice president is not a nominee. And if not a nominee, not a candidate. So he has the right to withdraw because he's actually not a candidate. If it was Mr. Who's of Sunny Day, who is a candidate by the constitution, right, that he is withdrawing, then the EC would have a problem with the CI. So this, I come to know that the president is not an elected person by the constitution. Thank you.
Okay, thank you. So you people, today the councils are quoting a lot of laws and are making some inferences on the laws that are not supposed to be done. Now, I take Article 37 and Article 18, which you have been quoting, that the vice president is not a candidate. You've made mention of the fact that the vice president is not a candidate. You are set to that fact. Exactly. So when you go to Article 21 of this Constitution, Clause 2, it states categorically that a candidate, listen, you have made the assertion that the vice president isn't a candidate. A candidate for the office of vice president of the SRC shall be designated by the candidate of the office of president before the election of the president. So, in as much as he is not autonomous, his election is tied with that of the president. So making inferences that he is not a candidate and he is not nominated, provided that there is a slot given to him under Schedule 7 of the Constitution, is actually misleading.
My Lord, Article 37, my Lord, Article 37, Clause 1, it states, a student shall not be a candidate. This same goes for the word abortion that I used.
No, wait. But listen.
Let me please. A student shall not be a candidate. Article 37, Clause 1. A student shall not be a candidate in any election unless he is nominated for election as president, secretary, treasurer, or women's commissioner by a document. So based on this Article 37, that's a made assumption. Yes, Article 21 talks about candidate, but Article Chapter 6 is on elections and qualification. And that's where the first statement of qualification candidate is supposed to be challenged.
So what I want you to understand that making the assertion that the vice president is some ghost body in the constitution is wrong. Listen, in as much as he is an autonomous body, there is a provision in the whole constitution for his office, which says that a candidate, it doesn't state that someone picked or anything. A candidate is stated categorically, a candidate for the office of the vice president of the SRC shall be designated. For the avoidance of doubt, they told us how that designation should be made under Schedule 7 of the Constitution. Am I wrong?
You're right.
Exactly. So why are you trying to make the assertion that in as much as there are 4 elected executive officers, the vice president is not autonomous and hence his election as an executive officer is actually tied with that of a president. So don't mislead the court into saying that he is not part of the nomination or he is not a candidate for election.
My lord, if the candidate for election
Exactly.
is stated in Article 37, is the candidate for election, if I say candidate for election, is in Article 37.
So who is a candidate? Who is a candidate?
So per Article, per Article 37,
Exactly.
per Article 37, that's what I'm using because that is where the topic is elections and qualification. Article 37. That is where the qualification is. A student shall not be a candidate in any election. So we're talking about elections here. So when it comes to election, it says that a student shall not be a candidate in any election unless he is nominated for election as president, secretary, treasurer, and women commissioner by a document. Here was not made mention that the vice president is a candidate for election. So what I'm talking about is a candidate for election, not just a mere word of candidate.
No.
Candidate for election.
Wait. The word candidate is self-explanatory.
No, it comes to context.
Into context here is that he is now a candidate together with the president, but he is not autonomous because if there's a provision that has been made under Article 21 and the Schedule 7 gives actually how he is part or how he is fused together with the president. Now, in the spirit of the Constitution, it places a premium on the president in the sense that the president is actually the head of the whole thing. Not as much as our Constitution gives power to the SRC to be the highest decision-making body of the land, the SRC presidency is actually the highest executive portfolio. Executive portfolios are the ones that run the entire SRC. So now, to avoid the break in governance, when something happens to the president, provisions have been made for somebody to assist him. Even when you look at the duties of a vice president, even the word vice president or the word vice is not the same as deputy. Now, vice is somebody who can actually take steed when somebody is not available. So it makes the presidency in a way that it packages the presidency, the spirit packages, it is in line with the 2 heads are better than 1 notion. So with a particular president, you need somebody who is attached to him in order to what? Go. So in as much as he is, I'll show my face on the ballot paper. Me in the background, I can also be a president one day in case of anything happens. I hope you understand that fact. So you cannot just belittle the office of the vice president with inferences due to Article 37 stating that nomination. So now the presidency now is something double. It's 2 in 1.
My lord, it's not stated here as double. It doesn't say the president.
No,
because
even when you are looking at the nomination of the, because under 37.1 has to do with nomination of the document. And the Schedule 7 stipulates how that document is actually written. True or false?
Yes.
So if that document that gives credence to the president states that there must be space for somebody else over there, you shouldn't disqualify that person as not being a candidate because his name is not under Article 37.
I'm not taking me as not a candidate. I'm taking as not a candidate for election. Those who are going to vote on as candidates of election, because that's what people are going to vote on. That's what Article 37 6 will explain, that people that are going to vote on are candidates of election. So that's why in Article 21, he never stated the person as a candidate of election. He just stated the word as candidate.
A candidate for yes.
Yes, but Article 37 says that the student shall be a candidate in any election. So this is candidate for election. So election, that Article 18. Okay. The first part of it talked about
okay,
this.
So the 37, let's go to the 37.
Let's go to the 37.
Because so it states that categorically that now a student shall not be a candidate in any election unless he is nominated for election as president, secretary, treasurer, women's commissioner by a document. So in that document that gives credence to the presidency, does it make space for somebody to be there as a vice president, as a deputy? It does. So it makes him in line with the president.
My Lord, the Constitution, yes, makes a provision, and we could have recognized them, both of them, as presidential candidates. Now, let me go to the CI 126, which is used to vote. In Ghana, there are two nations in Ghana. CI 15, the CI 15 is 1996, but CI 126, which was in 2020 to vote, has only two nominations. And the first nomination are for parliamentarians, and the second nomination are for presidential candidates. And that is only one person which sits as the president. And that part, the clause which CJ read Article 60 clause 4, that you should have a designate. But the electoral commissioner pay attention to the president because he is the candidate of election.
Exactly.
I'm not saying that the vice president is not a candidate, but not a candidate of election. And the whole thing, this whole issue right here is because of election. The whole thing right here is the whole reason right here is because of the election. So that the chapter 6, which is election and qualification, talks about people who are candidates of election. And yes, the provision was made in the provision is made in Schedule 7, but the Constitution made only the president stand on his own, and that is what is on the file here, federal president. So they're saying that I'm not misleading the court. They're not saying the vice president is not a candidate.
No.
But Article 37 states
so you are stating that he is not elected.
He's not a candidate of election, so he's not elected.
So
when you say elected here, it's election here is those who said a student shall not be a candidate of election unless it's nominated for election. You're talking about these people that you're going to vote for. They are the candidate of election. People are going to vote for. And you even said in your earlier statement that you vote for the president, not the vice, and the other portfolio. You made mention of it. So they're talking about people you are going to vote for as candidates of election. So the vice president is a candidate, but not a candidate of election.
What I want you to understand is that I'm not disproving what you are saying. I just want to make you understand that the inferences which you drew are a bit misleading. So don't try to overplay the presidency and underplay the vice presidency role. What I want you to understand is that in as much as the person is not, the vice presidency is not, he is an elected officer. Listen, he is an elected officer, but not an autonomous elected officer. Because when you take his oath, he swears the oath as an elected officer, not an appointed officer. Do you understand? And that he takes the oath as an elected officer. So, in as much as he's not given room under Article 37 and Article 18 of the Constitution, he is, together with the president, an elected officer. But his role is not autonomous.
My Lord, from Article 60 of the 1992 Constitution, that the CJ read, made it say that for someone, the vice president, to be the person designated for vice president, to be the vice president, it means that the one who has won the election, which is the president who appointed him, to win the election in which he has.
Presidents don't appoint vice.
But the word designate
Exactly.
Means
A designate and appointment are two different things.
you can check the meaning of designate
No.
on Oxford Learned Dictionary.
No. Listen, when you say appointment, because when you take our constitution, there's a categorical place where when you look at the office of the vice president, so for the office of the vice president, when you read Article 21, it states that a candidate of the office of the vice president of the SRC shall be designated. So when you say appointment, in the same constitution, there is a place where a president can appoint a vice, and which does not apply under this 21. So that's why I want you to understand that when you use the word designate and appoint, it can be misleading because in this our constitution, there's a portion where a president can actually appoint a vice president. I hope you get it. So before the election, he's a designate. So you don't say that appoint a vice or a running mate. You get it?
My lord, the word appoint you are using is also in Schedule 7, Clause 1B, saying that the vice president, the nomination form of the president shall have a column. For the name of the vice president, he or she intends to appoint. And the 21 is also using the word designate. I want to check the dictionary. The word designate means appoint. A person who is appointed and is fixed for a position, appoint. The word designate in Oxford Learned Dictionary is appoint. And the Schedule 7. Schedule 7.
Let's proceed. Let's proceed. So it's not going to. So now, so everybody has used it. So the cross examination. So the defendant, the counsel for the petitioner is allowed to, is given room to cross-examine the defendant.
So, my lords, can the defendant approach and make his way to the stand?
Cross-examination.
I
Hubert Bate,
do hereby in the name of Allah swear
do hereby in the name of Allah swear
that everything I shall say here shall be nothing but the truth.
that everything I shall say here will be nothing but the truth.
So help me Allah.
So help me Allah.
Thank you very much, Honorable. Please take your seat. Mr. Hubert, please take your seat. Mr. Hubert,
No.
did you verify Mr. Oblite's transcript when he filed for nomination?
No, did not.
Did Mr. Oblite write a consent form as stipulated in your CI for every aspirant that he's giving you the consent to actually check the transcript?
The vice president is not elected for, so not an aspirant. So then he doesn't need to submit a consent. He is not elected per Article 18. Therefore, to be elected, he's not, but he's not supposed to be voted. So hence, he's not aspirant, and his name does not even appear on the ballot paper.
Overruled. Thank you very much. Please answer the question. Please answer the question. The same question.
All right. Okay. So I did not follow up with the transcript because I didn't see him being deemed fit in the position as an aspirant.
You didn't answer my question. Did he give you a consent form as you have actually asked all aspirants to do based on your CI? A consent form to go for a transcript. Did he?
No, he's not an aspirant. So in the first place, I don't see the reason why he has to give me a consent form for that.
You heard that objection overruled. I'm submitting to you that if you didn't, then you went against your CI. I put it to you.
Why?
I put it to you. Please, you don't have the right to ask me a question. I put it to you that if you didn't take the consent form from him, you went against your CI.
Oh, I don't believe.
When did Mr. Oblite submit his resignation letter?
Okay, so.
Hello, I have 7 minutes for this process application. Hello, 7 minutes.
So it was 4th of August.
4th of August. And when did you write your communique on his resignation?
Was the next day, which is 5th.
Okay. Did you accept his resignation?
I did.
Okay. I put it to you that if you didn't receive any consent form and you actually didn't take his transcript, then you never assessed his CGPA.
I don't have to assess the CGPA because he's not an aspirant. Per the Constitution, he is not an aspirant.
My Lord,
so I will not follow up with
Lord,
that.
this answer is not to the value of the question. If you overrule that, he's making an allegation something that's not in the matter.
No. You asked me a question, so answer how I will answer you. All right? That is the question.
Can you please sit down? My Lord, no. Please proceed with your next question.
Please silence in the court.
If you accepted the nomination of Mr. Oblite, I put it to you that you went against your CI, which says that only within
objection. In the Constitution, Schedule 7, the Vice President is not eligible for a nomination per Schedule 171B. So then there's no nomination. This is the President. The name is written boldly. Federal President. So the Vice does not have a nomination. So if he's saying that he has a certain nomination, the Constitution does not make a provision for nomination. Have any bearing on the Constitution?
So if you accepted this resignation, I'm putting it to you that you went against your CI.
I said I did not go against my CI.
Did you assess the forms of Mr. Sunny Days as well as Mr. Oblite during the nomination stage before the vetting stage?
What do you define by the word assessment of his nomination form?
Lord, this is not the answer to the question.
Oh, an answer? Are you listening, please? An answer? I'm also asking.
Did you check for the eligibility of the forms of Mr. Sunny Days and Mr. Oblite before proceeding to vetting?
Objection again, my Lord. The Constitution does not Sorry, my Lord. Constitution, the portfolio here is nomination of the President. There is not a nomination of the Vice. So then he's saying separating that did he accept the nomination of the President and accept the nomination of the Vice? The Constitution made it clear what the Vice is supposed to bring on board, which is Article B 2. Article 38 clause 1 is what we are supposed to assess, and that's the CGPA. So if he's asking in conjunction that did he assess the GPA or the document of the President and the Vice, it does not hold because the Constitution only makes provision for the President. Article 38 clause 2 is said for executive officers, and Article 18 makes present that there are 5 federal executive officers. So then you don't sustain an objection
Please,
Derogatory remarks should not be made towards the bench. Anyone caught making such remarks will be walked out and will be found in contempt of court. Please, all opinions regarding what is happening here, if you are not called to speak, should be kept in your head.
The gentleman in the wine shop, please do the needful. Behind the curtain, at the back of Gertrude.
And please, I also want to say something. I heard someone say that I wish you can also come and take this seat. And then you are the all-knowing person who knows everything in this world. I heard somebody say Onimche. I don't know anything.
I don't know anything.
That's what I'm saying. That's why I'm in school in the first place. So you are the all-knowing, omniscient human being.
Order in court. Please. The CJ made an assertion that we don't clap. Here is not a prayer camp.
Rebels, go out for 20 minutes and return. Leave my court for 20 minutes. There's water at the back. You can drink some on your way. 20 minutes.
So please, I ask that the omniscient person should come and sit here and then knows everything in this world. Should be able to give us the basics of please. I give you my seat. You can come for it. The one who said Onimche, please come for it. Sometimes we forget that we are all students and we are all here. You know the number of times or the number of nights I've lost legs because of all these petitions. And the fact that I'm not talking doesn't mean I don't know anything. We have sat down to deliberate on these issues and we ask that some of our judges be our mouthpiece. So the fact that I'm sitting and I'm not saying anything doesn't mean that I don't know anything that we are talking about. If you know everything,
Okay. That's why I stated clearly earlier. If any derogatory remarks are supposed to be made towards the bench, please keep them in your head, because you will be found in contempt of the court, and this will be processed as a disciplinary committee case. And you will not come and write any petition against anything. It is not allowed for you to write a petition against when you are being processed to a disciplinary committee. So please take this as free advice and keep your remarks in your head until you are called to speak. Thank you. So, Foreman, you have 3 minutes more.
No, my lord, whether the objection is sustained or
okay, she.
If you rightly said through your counsel during your statement that the vice president is not a candidate, then who is he?
You are wrong again, because he's a candidate, but not a candidate to be elected. That is one thing you also got it wrong. Please have an answer.
My lord, I asked a straight question. Who is he?
Please, you can't make an assertion that someone is wrong while you are answering the person. The person has asked you a question, so you can't tell the person he is wrong. What have you heard that he is wrong?
I'm sorry.
What have you heard that? So when you've already been cautioned. Counsel, I think you should speak to your client. The way he is answering some of the questions is actually not good.
My lord,
the
I'm sorry.
Gentleman sitting by after the guy in the flower top, Pounds, kindly leave the court. You've enjoyed our court for some time now. Take water on your way.
So please,
I'm sorry.
You are not sorry to me. You are supposed to say sorry to him.
I'm sorry.
Hope it doesn't repeat itself.
Yes, please.
who is the vice presidential candidate? Is he an aspirant or not?
He's not an aspirant.
In your CI, right after nominations, there is vetting of aspirants. Whom did you vet?
It was made known that the vice president is not autonomous. He is not standing alone.
I put it to you that you vetted an aspirant.
Objection.
No. See, this are the type of reactions that we don't want to be seeing. Listen, when you're young, I said young man. Listen, client, defendant, please. Defendant, please. Now, when you are asked the question, you're in a witness booth. A witness booth, when you say booth, you don't go out of a booth and be doing anything. When you're in a call booth, you are there stand. You don't use your telephone and be walking around. This is not a mobile phone. When you're at the booth, you stand there.
My lord.
Okay, you are in your booth. So you're a witness booth. So please be there. Stop moving around and answer questions. If there's anything you want from your counsel can raise a point of order, then we can either give him to either object or sustain his.
Okay, my lord.
I put it to you, straight, I put it to you, that you vetted aspirants per your CI.
Article 46, vetting of the SRC Constitution. D. The vetting committee shall be responsible for ensuring that the candidate for any election. It goes back again to Article 37. The candidates for election are the four portfolios. Article 46 clause. Article 46. It says that the vetting committee shall be responsible for ensuring that the candidate for any election under the Constitution. And under the Constitution, it is stated even in Article 18 that there shall be 5 federal executives, of which President, Treasurer, Secretary, who come is elected under the Constitution. So per this, it means that the vetting committee is not supposed to vet. And the president being there, the vice being there does not mean that he was vetted. Because, he being there, there's another proposal they have to ensure in Article 38 clause 2. Article 38 clause 2. Article 38 clause 2. A person shall be qualified for executive office. So now this qualification, once the vice president is by the president, the vetting committee make sure that these things do not hold.
I know I've been keeping track of the time. I know there have been stops and all that, but time flow is time flow. So please let him. He was objecting to something. So it has not been either sustained or. So let him finish.
Article 38 clause 2 gives all qualifications for executive offices. So during the vetting, this has to be made known that is the vice president who is executive officer. Is he a person who has been declared to be misappropriating of funds? So all these things have been made into the character of the vice president and not to check his CGPA or any other document which is not prescribed. The document to be sent to the vetting is in 38 plus 1. So if he is vetted, the question is the vetting committee as what did they vet? If they vetted him based on the CGPA, that means they didn't do what's in the Constitution. That means what they did was even unconstitutional. Because based on the
to say,
so I'm sorry,
no, wait. What you're trying to say, what you're saying is that your client here, the defendant, who happens also to be the chairperson of the vetting committee, has flouted laws of which you are proudly defending.
No, he asked a question. He asked a question.
No, in your No, you are objecting to something.
Yes.
And you are making a case. And in your case, you have stated that it is an illegality in the first place. Or that is not what
It's
you are
an
saying.
illegality based on what he is being vetted for.
Exactly. That is under 38.
So yes, so
that
then,
is what you've quoted.
yes. So it's in an illegality. What is vetted on? So then the question is asking whether he vetted him or not. Does not make a case, because you have to ask on what questions was he vetted on.
No, you can't say on what questions was he vetted on. If you yourself have made provisions as to what the person should be vetted on, under 38, so you can't say whether he should be vetted or not. So overruled.
Go ahead and answer the question. The question is, did you vet Mr. Oblite as an aspirant? Thank you. Please repeat exactly what you said.
Yes, I did.
You vetted him as an aspirant.
Okay, thank you. Your time is up.
My loss, just
time flow is time flow. You can actually stop time and continue. It's not something that we take and we are just counting. Exactly. We proceed to call the counsel of the defendants to cross-witness the petitioner.
My lord, in this case, I approach the bench, because in this case, both of them are petitioners. And
But in this case, it was asked, since they are the petitioners, we asked them, who is the legal representative and who stands in to be the witness or the petitioner? And they themselves ascribed to who should be the.
So that was not meant to us.
Okay. Are you okay now?
Yes.
Or you wanted to choose one yourself?
Oh, no, I came to the bench and he said, but so I could have, what does that mean, good? That's what I was asking. Thank you.
I
AJ Godwin Reggie,
do hereby in the name of God Almighty swear
do hereby in the name of God Almighty swear
that everything I shall say here
that everything that I shall say here
shall be nothing but the truth.
shall be nothing but the truth.
So help me God.
So help me God.
Oh, please, you can sit down. Gordon, Mr. Gordon,
Yeah.
I want to ask, were you part of the vetting committee?
Yeah, I was not.
So, in your opening statement, your legal counsel made a statement that you checked all the transcripts that came. Okay. So, please, did you see Mr. Oblite's transcript?
No, please.
But you said you checked all transcripts that came, and you never raised argument based on that. Did you?
I raised an argument because I was the one who was even.
When did you raise the argument?
I asked.
When did you raise the argument?
So when we were glancing through their transcripts, when I saw the presidential one, that is Mr. Sunny's, and I asked of Mr. Oblite's own, and the answer that he gives that he was having issues in getting access to his transcripts.
So then, why did your in opening counsel say that you inspected all and without giving an exception to that?
No, he said that he inspected all in the sense that was what was presented to him.
The word all means all.
No, that was what was presented to him.
Please. Now, you are making use. You are using some words that are not supposed to be used. Now, wait. I'm not saying that doesn't mean you does it. What do you know? I'm saying that you are saying that. What do you think I'm going to say that I think that? I didn't see the place. So what I want to say is that transcript is when you have completed. It's statement of results. So there are two different things. A transcript is given. I saw it in the CI. So I understand that is why people are using it, but it's actually a statement of results. Whenever you print as a continuing student, when you go for something like that, they give you a statement of your results, not your transcript. So please, and a detailed results. So but the title is Statement of Your Results. So that is what I'm doing. So please use it.
In open statements, your counsel made that you inspected all without any exemption. He even boasted that, he even proud himself with that because of that they disqualified someone. So if there was an exemption, why didn't he state it in the opening statement?
He is saying that it was all in the sense that was what was presented to him by the EC. And he is the one that is working. So this is what I'm giving to you to work. So this is what I have. So that's why he's saying that.
So why then didn't you raise the allegation right after the vetting, but wait until the eve or the day before the election to raise that his transcript is, he didn't say his transcript, he said we should bring a document, which you know from the statement now that the EC didn't have it on the day of vetting, to present the document to you or to the court for us to look at whether he had the requirement. Now you knew that during the vetting it was not there. You never raised an argument. Until that, then I said that I put it to you.
It's not that we never raised an argument.
No, so
the issue here is that the issue here is that I asked and Mr. Oblite presented. It was just I think it was a printout of the portal. When you print a document from the portal, how is it? That was what he presented. You get it? And I presented it to my EC. That is what Mr. Oblite has presented. And he told me that he's going to work on it. That is that. You get it? So I expect my EC to go and check and make sure that the right thing is done.
So now you are saying that he didn't even present it in any first stage. Now you are saying that he presented a copy of it.
I'm not saying a copy. I'm not saying a copy of the statement. I'm saying that a copy of something that is in the like you see when you print something from your portal, the results from the portal. Yes, he presented that one. You get it? And my EC was sitting just beside me, and I presented to him that this is what it is there, and he told me that he will work on it.
So then he brought a statement of results.
That was okay. Let's take it like that. But that is not the official one that was requested.
No, not about official.
Your client is actually answering the question before you raise your order. Now, don't be saying point of objection or those things while when you are not given the opportunity to talk, then you just stand up and you talk. Wait, your client is answering questions and you are objecting. I understand it may be futile to your case, but it must be in a well-coordinated manner. You have to listen to who is talking. He is in the witness booth. So if there is something, when you raise, you should keep quiet and listen to your counsel. So overruled is an education to you. So the next time, we'll continue.
So yes, he presented a document of statement of results. That's what he replied.
Objection, my lord.
He already replied as yes, so I'm just repeating his statement.
It was a previous question. I get it. It was a previous question which he answered. So he restated, how do you say? He restated the question. So it is a question that has already been asked and answered. So he's just given affirmative. He wants to find the affirmative of the question he already asked. So continue.
What was the CGPA on that statement of results?
Okay, I will call that a statement of results because it wasn't what was officially requested. So that's why I asked I sent the thing to my EC that this is what the person is complaining that there was an issue, so he was not able to get access to the required one. So he is representing this one. So that's why I just gave it to my EC.
Have you opened your student portal before?
We've opened my student portal before.
When you open the student portal, there's a column that shows course education, then.
Yeah.
There's a column that says statement of results, right or wrong. There's a portion of that column that states statement of results. You are saying you don't go to statement of results, but on the column, there's a portion that states statement of results. Have you seen before?
Objection, my lord. My lord, he is pointing out the process of which he gets something. My client needs to actually verify that before he gets to know the part of the issue. He's saying something that he knows, but my client doesn't know that. So to be fair to him, let him open his transcript and perhaps answer the question. Let him open his transcript. His portal, as he said. To be fair to you, on what he's asking.
So sustained, open it and verify. We add a minute to it. So right, you still have 2 minutes.
Please, as stated earlier.
I can't say levels. I guess you 20 another 20 minutes. Please, if the more you object, the more you extend the time. So it is. So you said, and I'm quoting, the assembly. Is that not what she said? Levels, 20 minutes. Go and drink another sachet of water. Thank you. Levels, the assembly.
Is there anything like statement of results?
Yeah, there's this.
So and click on the statement of results. What shows the results? Was it this that he presented?
Yes, he
So then
presented.
wait, you said what he presented is not statement of results.